Hare Krishna. Welcome to Tax YouTube channel. This is C. Rohan Arping, a practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says, and today we are going to discuss two important case laws under income tax law. So let's dive into it. Let me allow to share my screen. Yes, so in this sessions, we will review two important income tax judgments from High Courts in February 2026. The goal is to deepen our understanding of current direct tax jurisprudence and extract sound legal principles that affect what tax administration, treaty application, and appellate litigation. So the first case examines what withholding tax classification and consistency in tax positions for non-resident services, an area critical to cross-border businesses. The second case, whereas highlights what procedural safeguards in departmental appeals, the role of limitation and the correctness in handling the tax refunds and appellate records. So these cases not only clarify legal provision, but also provide guidance on handling disputes at various stages from departmental action to the High Court intervention. So let's start with it. Our first case of discussion, PGS Geophysical AS versus Income Tax Department, Delhi High Court, date of order 12th February 2026, pertaining to ongoing withholding obligations linked to the contract receipts during financial year 25-26. So let's understand facts of the case. So petitioner was PGS Geophysical AS, that is Norwegian non-resident company, and respondent Income Tax Department, International Tax Circle. So the background, let's see, the petitioner provided what seismic survey and data acquisition services to ONGC for offshore oil and gas exploration. The department issued a withholding tax certificate under Section 197 of the Income Tax Act 1961, requiring 7% TDS on amounts paid to the petitioner, characterizing payments as fees for technical services. So the petitioner challenged the TDS order before the Delhi High Court on the grounds of incorrect characterization and inconsistent treatment from earlier years. So what is the issue? So these are the issues under consideration. Whether seismic survey and data acquisition services qualify as fees for technical services or royalty under the Income Tax Act. Whether the tax authority can impose a 7% withholding rate when prior year's positions and treaty applications suggested otherwise. Whether the action was contrary to the binding judicial precedent and principles of consistency in tax administration. Let's see what are the relevant legal provisions. Here, Section 197 Income Tax Act 1961 plays important role. Power to grant withholding tax certificates, that is including reduced rates for non-residents. Domestic tax rules on FTS and royalty, that is foreign technical service, how service recipients to non-residents are classified, and international tax principles, double tax avoidance agreement implications, though not explicitly treaty-based here. Classification impacts what cross-border taxation and inconsistent assessment affect certainty. Let's see what are the grounds of the petition. The petitioner contended that the services were already treated at a lower withholding rate in earlier years. Seismic survey services do not constitute FTS or royalty per prevailing case law. So the impugned 7% rate was what inconsistent with earlier orders and lacked proper justification. Let's see what High Court observed. The High Court assessed that the tax department's order didn't clearly explain why a different tax treatment was applied compared to earlier years. Precedent in related matters held similar services not taxable as FTS or royalty. The authority's failure to demonstrate the substantial change in facts or legal position was problematic, and the procedural requirement to provide reasons in tax orders is imperative, especially when shifting from prior established positions. Very important. So what High Court held that the Delhi High Court held that it set aside the 7% withholding tax certificate issued under Section 197, directed the AO to reconsider the matter and determine the appropriate withholding rate consistent with past treatment and binding principles, emphasized that the services were not automatically taxable as FTS or royalty without proper justification. So, what principles led down this first case? Consistency in tax treatment is very important. So, tax authorities must explain reasons for deviating from the already established positions. Classification of non-resident income. Services like seismic surveys must be correctly characterized by applying FTS or royalty provisions. Requirement for reason orders. Its proper reasoning is necessary, is mandatory, and in withholding tax certificates under Section 197. And judicial oversight is high courts ensure fairness and prevent arbitrary deviation by the departments. Is what these are the principles we can lay down. So moving further, today's second case for today is Principal Commissioner of Income Tax 4 versus HCL Infotech Private Limited. Date of order 11 February 2026. Very latest order. Court involves Delhi High Court and assessment year relevant is 2014-15. So let's understand facts of the case. Appellant Principal Commissioner of Income Tax 4 New Delhi, respondent HCL Infotech Private Limited. The appeal arises from an ITAT order that is dated 15 September 2023, affirming that the CIT appeals order on issues including refund claims for assessment year 14-15. So the department filed an appeal against ITAT's dismissal along with an application for condonation of delay in refiling the appeal. So let's see what are the issues under consideration. Whether the department can condone the delay of 690 days in refiling the appeal, whether the tribunal's order on refund claims was correct and sustainable, and whether the High Court should entertain the appeal against the ITAT decision. So let's see what are the relevant legal provisions involved here. Section 5 of Limitation Act 1963, that is condonation of delay. Section 151 CPC, inherent powers of the High Court, and income tax appellate provisions, that is powers and jurisdictions of CIT appeals, ITT, and High Court in appeals and refunds. So let's see grounds of the department contended that the delay in refiling the appeal was due to valid and sufficient reasons warranting the condonation under the Limitation Act. The High Court ought to consider the appeal merits despite the delay, and the refund denial or order of the tribunal was flawed. So these are the grounds of the appeal from the department side. So let's see what High Court observed. The court first addressed the condonation application, holding that the department had provided reasonable explanations for delay. Okay, so it was appropriate to allow the appeal to heard on the merit. So on core issues, the court then considered the correctness of the tribunal's order on refund and appellate record. The precise outcome on substantive issues will depend on further arguments and orders on merit. So, but the preliminary holding on condonation allowed the appeal to proceed. So what High Court held, that Delhi High Court held that allowed the condonation of 690 days delay in refiling the appeal, directed that the appeal be admitted and heard on merits, and rejected any technical barring based merely on delay given sufficient justification under the Limitation Act. So what principles laid down by this case? So condonation standards, delay can be condoned if and only if reasons are sufficient and credible, especially for the department appeals. So merits over the technicalities also. Avoid undue emphasis on procedural delay if the substantive controversy merits judicial determination. So High Court's inherent jurisdiction is applying the Section 5 and Section 151. Courts ensure justice rather than literal exclusion due to time. So, while conclusion, in conclusion, these High Court decisions provides what vital legal clarity on the contemporary tax controversies. In first case, the Delhi High Court reaffirmed the need for reason orders, consistency in tax positions, and correct classification of non-resident income. This contributes what significantly to the international tax certainty. And in second case, the focus on procedural fairness underscores the High Court's role in preventing the justice from being defeated by technical delays. So both cases collectively enrich the jurisprudence on substantive tax liability and procedural fairness in litigation. So understanding these judgments helps what practitioners and taxpayers navigate the appellate pathways more confidently and fosters the fair and predictable tax administration. So that's it for today. Thank you. Thank you so much for patient hearing. Please note down my contact numbers. If you have any queries, observations, suggestions, questions, then please do let me know via WhatsApp, via email, and you can also comment below the video. Hope you are gaining valuable knowledge from these updates and video series like this. If you are not yet subscribed to TaxGuru YouTube channel, then do subscribe to TaxGuru YouTube channel for latest updates and video series like this. So thank you so much once again. Bye bye. Take care. See you soon. Hare Krishna.